Let us discuss the landmark case which transformed the legal handling of criminal negligence accusations against the Indian medical professionals. In this case, a patient was admitted in a private ward of a hospital in Punjab and developed an episode of difficulty breathing during treatment. The patient's son contacted the duty nurse and two doctors came to examine the patient after an alleged delay of 20 to 25 minutes. On connecting the oxygen cylinder, breathing problem increased further as the oxygen cylinder was found to be empty. There was no other cylinder available in the room. The patient's son brought a cylinder from the adjoining room. Yet, 5 to 7 minutes were wasted in making it functional. By this time, another doctor came and declared that the patient was dead. Aggrieved by the death of the patient, the family members complained to the police that death had occurred due to carelessness of doctors and nurses. On the above said report, a criminal offence was registered under section 304A and 34 IPC and FIR was filed against the two doctors. This step marked the beginning of landmark Mathew versus State of Punjab case that went on to become one of the most significant developments in medical law. To quash the criminal proceedings against them, the doctors filed revision petitions at Sessions Court and the High Court of Punjab and Haryana, but all such requests were dismissed. At last, they filed a special leave petition to the Supreme Court to quash the criminal proceedings. Here, the doctors stated that the patient was terminally ill cancer patient and could not be admitted in any other hospital in the country. The relatives were informed that nature and severity of the disease required only palliative care at home. Still, the patient's relatives, being highly influential people, could prevail over the management and the doctors and got him admitted in the hospital. Despite making every conceivable efforts, the patient died, as what was ordained to happen did happen, and that the complainant lodged police report under the misguidance or mistaken belief of facts. The Supreme Court allowed the appeal. Here, doctor's petition made a reference to a previous judgment of 2004 Supreme Court case, Dr. Suresh Gupta versus Government of NCT of Delhi. This matter was initially heard by a bench of two judges who noted that in Dr. Suresh Gupta's case, the judges had used the word gross while reading section 304A of IPC that introduced degree of rashness or negligence as an added expression. They inferred that different standards cannot be applied to doctors and others. A doctor cannot be placed on a different pedestal for finding out whether rashness or negligence was involved. So, to clarify the matter, they referred the case to a three-judges bench. Overall, the bench narrowed it down to two questions for decision. First, is there a difference in the civil and criminal law on concept of negligence? And second, whether a different standard is applicable for negligence of a doctor. The court discussed the difference between negligence under civil and criminal law, that extent of liability in tort law, that is civil law, is determined by amount of damages, but in criminal law, the liability is determined by amount and degree of negligence. Naturally, the degree of negligence has to be higher for criminal liability. The court referred to a passage from the judgment from 1980 which commented on standard of proof required for liability. Here it was said that in civil proceedings, a mere preponderance of probability is sufficient, whereas in criminal proceedings, the standard of proof has to be beyond all reasonable doubts. After reviewing the literature on matter, the Supreme Court confirmed that degree of negligence is a significant factor for differentiation in tort and crime. They said that the expression rash and negligent act of section 304A of IPC has to be read with word grossly. Here the principle of law established in Dr. Suresh Gupta's case was validated, and the bench commented that negligence which is neither gross nor of a higher degree may provide a ground for action in civil law but cannot form the basis of prosecution. After differentiating various aspects of profession and occupation, the bench concluded that negligence in a professional activity is breach of duty caused by either omission to do something which a reasonable man would do or doing something which a reasonable man would not do. Its components were identified as duty, breach of duty, and resulting damage. Here the court said that negligence of medical professionals calls for a treatment with difference, pointing out that medical negligence can be assessed by Bolam test, which holds good for application in India. And also the court highlighted the critical role of mens rea for negligence under criminal law. The bench stated that for negligence to amount to an offence, the elements of mens rea must be shown to exist. The court observed that there was a rise in number of criminal prosecutions against doctors and listed various limitations in the investigation procedure. They found that lack of medical knowledge on the part of investigating officer often leads to premature initiation of criminal proceedings against the doctors. Such prosecution causes serious embarrassment and even harassment of doctors. Later, if the doctor is not found guilty, the loss suffered in reputation cannot be compensated by any standard. Also, the criminal procedure may be abused as a tool for pressurizing the medical professional for extracting unjust compensation. The court noted that in interest of society and need to protect doctors from frivolous prosecutions, the bench put forth a set of guidelines for handling criminal negligence complaints against doctors. The bench directed that a private complaint may not be entertained unless the complainant has produced prima facie evidence before the court. The evidence that is credible opinion by another competent doctor to support the charge of rash or negligent act of the accused doctor. Second, before taking action against a doctor accused of negligence, the investigating officer should first get an expert medical opinion, ideally from a government doctor in the same field, who can give an unbiased view using the Bolam test. And also, doctors should not be arrested routinely just because someone has filed a complaint. At this point, the court listed 3 conditions for arrest. First, if it is necessary for the investigation. Second, to collect evidence. And third, if the investigating officer believes that doctor may not make himself available for the prosecution unless arrested. Coming back to the facts of the case, the court found that even if all the claims in the complaint were true, they did not amount to criminal negligence or rashness on the part of doctor. The doctor in question was qualified to treat the patient, and the issue raised was about non-availability of oxygen cylinder, something that may point to hospital's fault but not the individual doctor's criminal liability. At last, the Supreme Court of India not only quashed the criminal proceedings against the doctors but also initiated a system of investigating criminal negligence charges against the doctors. The court highlighted the need of framing statutory rules, executive instructions for prosecution of doctors for criminal negligence. The Government of India and state governments were advised to frame the same in consultation with Medical Council of India. Subsequently, in 2017, the Medical Council of India released a set of guidelines to be observed by prosecuting agencies for protecting doctors against frivolous complaints. These guidelines suggested the formation of a medical board at district, division, and state level to examine the cases forwarded by prosecuting agencies. The National Medical Commission published a set of fresh guidelines under the similar heading. If you are interested in knowing more about this topic, then refer to the link in description box, as we have had the privilege of publishing an article on this critical issue. If you enjoyed this video, then kindly like, share and subscribe. And if you happen to have a query related to this topic, then drop in a comment. Thank you.